here at the home of my colleague, Professor Nicolas de Sadeleer in Forêt, or Forest, Brussels, to discuss his latest book, the second edition of Environmental Principles from Political Slogans to Legal Rules, published by Oxford University Press. Set in beautiful natural surroundings, as the name suggests, Forêt, or Forest, is an apt place to find a professor of environmental law, yet at the same time, the tranquility and the greenness of these surroundings might stand in stark contrast to the environmental crisis currently facing the world. And indeed, it is this crisis that provides the context for your monograph, which aims to determine the status of three key environmental principles: the polluter pays principle, the prevention principle, and the precaution principle, and to evaluate their contribution to the construction of environmental law, whether nationally, at EU level, or internationally. And actually, the first edition of this book was published in 2002 and, at the time, offered a valuable contribution to the debate surrounding environmental principles and their application, namely by opening new avenues for reflection on evolving international norms. However, environmental principles have since been thoroughly examined by the legal literature. Considering this, what is the added value of your monograph? Why return to principles already considered and analysed by you and other scholars?
Regardless the quality of the other legal works, it occurred to me that most of these analyses focused either on a set of principles within a single legal order or exclusively on one single principle, such as a precautionary principle. And the added value of my analysis is this transversal approach, embarking upon international public law, international economic law, as well as EU law, and a number of domestic legal regimes ranging from US law to Australian law. In addition to this, it occurs to me that many authors did not link up these environmental principles to general principles of law, such as proportionality, non-discrimination, good faith, legitimate expectation, legal certainty. And in my work, I constantly emphasize the intersections, the interaction between environmental principles on the one hand and the other general principles of law on the other hand. The second added value is the sheer breadth of the debate surrounding precaution or polluter-based principles with respect to environmental tax, with respect to carbon taxes. And it occurred to me that there was a need to hone my arguments with respect to the legal functions and the legal status of these three principles within different legal orders. Thirdly, often people tend to look at environmental law per se, standing alone without any interactions with other legal disciplines. In my book, I constantly discuss the manner in which these principles can influence other legal areas, such as tort law, criminal law, economic law. Fourthly, and I imagine this is the key added value that has been emphasized by a number of reviewers beforehand, is that in many legal analyses, legal framework, theoretical framework is missing, is lacking. And in the first edition, I stressed that there is a transition between modern law to postmodern law, from rigid, abstract general rules to much more flexible rules, norms. And the key drivers of these transitions did not fade away these last 20 years. To the contrary, they were exacerbated by a number of trends, rolling back environmental regulations, watering down environmental procedures, getting rid, like the US Trump administration did lately, a number of environmental safeguards. And so my legal theoretical analysis still makes sense against this background.
Environmental law is rife with principles of different nature found in a multitude of legal instruments, including, for example, the principles of sustainable use, of ecological solidarity, of proximity and self-sufficiency. The list goes on. Considering the richness and the variety of this legal landscape, Why did you place the focus on only 3 principles, the polluter pays, prevention and precautionary principles? Is your analysis not too narrow?
Yes, as a matter of course, environmental law is rife with principles. One is juggling with a flurry of principles ranging from extremely technical principles like waste minimization, so the principles of proximity, to extremely broad notions such as sustainable development. Many international treaties enshrined a litany of environmental principles. By the same token, domestic statutes list a huge number of environmental principles. So it occurred to me that it was impossible to cover in one single monograph all these 30, 40, 50 principles. It was much better just to focus on 3 principles for several reasons. The first reason is that the polluter pays, as well as prevention and precaution, stand alongside, next to each other, in a number of international environmental treaties, as well as in a number of domestic statutes. Secondly, in the case law of Supreme Courts, often they do stress a breach of both prevention and precaution. Thirdly, it occurred to me that there is a theoretical background that justify the focus on these 3 principles. In a nutshell, polluter pays principles relates to a curative approach under which state authorities clean up contaminated land, restored degraded habitats, polluted ecosystems. The difficulties with that approach is that somewhat too late, the polluter pays and the state authorities intervened, paying a very hefty sums in order to restore degraded ecosystems. So polluter pays has to be accompanied, has to be buttressed by a preventive approach, according to which the state authorities are setting forth standards above which the ecological damage is deemed to be unacceptable. However, that second approach does not take into consideration the long-term uncertainties we do face in environmental science. You know the saying that an ounce of prevention is worth a pound of cure. However, this is still a blind faith in certain science, in the certainty science can deliver. And that's leading to a third model to which the precautionary principle is related, is the model of anticipations, under which state authorities are called on to take action to prevent risks that are likely to entail severe, significant, irreversible damages in spite of the lingering uncertainties. So I did link up these 3 principles to these 3 models of thought.
One could argue that the principles you have focused on, the polluter pays, prevention and precautionary principles, are in fact deprived of a universal scope because, in reality, they depend upon the regulatory context upon which they operate. Does your analysis sufficiently consider the sheer differences between the different legal orders you explore? Does this difference not somehow undermine the universal scope of these principles?
That was the most significant challenge I faced in updating the book, to juggle with extremely diverse legal systems ranging from common law to civil law. I'm fully aware of the sheer differences between US administrative law and EU administrative law. Just look at the civil law family. There are significant differences between Italy, France, Belgium. So I did emphasize the background, the constitutional backgrounds against which each of these principles do operate. That being said, the fact that the meaning of each principle depends upon the regulatory context within which they operate does not deprive these principles of legal effects or of a general scope. And I would like to put forward 2 arguments. Firstly, the fact that these three principles are enshrined in a variety of multilateral agreements ranging from water pollution to water courses, signifies that they have a cross-cutting nature. Secondly, be it the no-harm principle, be it the principle of prevention, be it the due diligence placed upon states to conduct environmental impact assessment or to prevent significant damage caused to other damage, means that these principles are vested with the authority of customary rules. And so, all in all, it occurs to me that the general scope of these principles is not undermined by the specificity of each legal system.
Many critics would argue that the principles you have focused on lack any autonomous applicability. However, in your book, you emphasise that in a number of legal orders, they enjoy a self-standing nature. Could you comment on that?
Firstly, I wish to cross swords with many of my critics, according to which these principles are deprived of legal effects on the grounds that they're just guiding the administration, they're just enticing the administration to endorse such or such an approach. This interpretation is far too simplistic for the following reasons. One, again, must differentiate between the different legal orders, and in several legal orders, in particular in Western Europe, the principles are vested with somewhat level of legal authority, provided that two conditions are fulfilled. Firstly, a formal condition, according to which the principles must be stated, must be proclaimed, not in a soft law instrument, but in a hard law instrument, be it an industrial agreement, be it a regulatory statute, be it a legislative statute. Second condition is a substantive nature. The principles must be expressed in prescriptive terms in order to have binding effects. Inasmuch as the two conditions are fulfilled, these principles can be invoked in courts. And I provide a flurry of illustrations from case law, from French courts, Italian courts, the EU courts, the Court of Justice of the European Union, demonstrating that these courts do not hesitate to nullify regulations in breach of these principles. To put it simply, the fact that these principles offer leeway, room for maneuver to the administration, do not deprive them of their binding effect, inasmuch as the administration commit a misuse of powers or commit a manifest error of appraisal.
Climate change, or we might legitimately say the climate crisis, is embedded in lingering uncertainties, in particular as to the speed of the process and the extent of its impacts. Do you believe that precaution provides an answer to this threat? And if so, how?
What struck me is the speed with which the damages are caused, be it acidification of oceans, the rising of seas, moving of the range of species. I'm really astonished, as many scientists, by the speed with which these events do occur. What's also striking with respect to climate change risk, in contrast to technological or traditional technical risk, is the sheer breadth, the sheer scope of the damages, and the fact that these damages are spread differently across the planet and in time. In addition to this, as you do correctly stress, the lingering uncertainties are fascinating, be it the speed of the events, be it the magnitude of the impacts, be it the dynamism of the ecosystems reacting to this risk. Scientists are apparently completely at lost in dealing with these lingering uncertainties. And against these backgrounds, precaution still makes sense. So on the one hand,
the scientific knowledge has been constantly improving thanks to the IPBC, but on the other hand, the more scientists discover, the more challenge they do face. And so, again, it occurs to me that precaution, and I'm pleading strongly in my second editions in favor of taking precaution seriously in the fight against climate change.
And can you mention any recent case law where the court considered this principle in its analysis?
I did comment in my book to a great extent the Uganda case that has been handed down on the 20th of December 2019 by the Hoge Raad der Nederlanden, the Supreme Court of the Netherlands, in which an NGO, Uganda, contended with the policy endorsed by the Dutch authorities in curbing the greenhouse gas emissions. And they put forward the following claim that the laxity of the regulatory approach was in breach of Article 2 of the Human Rights Convention, right to life, and Article 8 of that convention, right to privacy. The Supreme Court of the Netherlands interpreted broadly these two provisions in light of the principle of precautions. Although the principle of precaution is not enshrined in Dutch legislation or in the Dutch constitution, nonetheless, the Dutch Supreme Court did apply precaution in order to embrace a broad interpretation of the two human rights provisions.
Very interesting. What's also interesting is that the precautionary principle arises exactly because there is scientific uncertainty. And one of the themes that you approach in your book is this tension between law on the one hand and science on the other. Can you comment on this tension and how you deal with it in your book?
Yeah, that was a serious challenge I faced on the account that from a positivistic approach, law stands alone. Law does not mingles with science or with ethics or with morals, as you are fully aware. However, science underpins objectivity. A scientific approach, a robust scientific approach, avoids that administrations or agencies discriminate undertakings in taking the false approach, in endorsing an unsustainable approach. So on the one hand, agencies need to underpin their decisions upon clear science. However, they have also to take into consideration these uncertainties. So the level of uncertainties cannot preclude the administration to ward off, to stave off significant risk damaging for the health or the environment.
Another tension you deal with in your book is the tension between environmental law and economic law, another very difficult tension to resolve, both politically and before the courts. Could you comment on this tension and how you deal with it in your book?
Yeah, I dedicated the last chapter, chapter 7, on the manner in which WTO law has been integrated, albeit imperfectly, precautionary approach. So the case law of the dispute settlement body in Geneva of the WTO has been extremely complex. I won't say they paid lip service to precaution. They did integrate some elements, although, as I said, imperfectly. And there I really delved into much more legal techniques with respect to risk assessment and the limitations of risk assessment. Again, we come back to this issue that scientific approach is limited somewhat in addressing, in adumbrating extremely complex risk. And tomorrow's world is clearly buttressed by this complexity of risk management in light of the limitations of risk assessment.
And that really brings us to looking to the future. And one of the issues you deal with in your book, and particularly in your conclusion, is how, as lawyers and looking to legal principles, how we approach this future and how we use these principles to ensure environmental protection. I'd like to ask you more on a more personal basis. Would you consider yourself optimistic or pessimistic with regards to the future, with regards to the ability of law, of legal principles, of the principles that you deal with to rise to this challenge that we are currently facing?
It's funnily enough, I always tell the students who are failing my exams, don't look at the glass half empty, look at it full. I'm fully aware as a former consultant there is a significant gap between law in the textbooks and law in action, and everybody practicing law is aware, in particular in the environmental field, of the significance of this gap. So I'm not too optimistic about the threats we are facing. Nonetheless, as lawyers, as university professors, we have the duty to serve the general interest and to advise the decision makers, making them aware of the importance to endorse a smart regulatory approach in dealing with complex and uncertain risks. And it occurred to me that the university should play a key role in influencing, in raising the awareness of the decision makers in tackling this risk. That's our duty, clearly speaking.
I hope it goes in that direction, and I'm sure that your book will provide much food for thought for not only academics but also practitioners. And it's been very nice to speak to you here today in this beautiful home. Thank you very much.
Thank you very much indeed.